The ground for the application are the applicant closed its case on the 15th day of February 2025 and applied for the record in this suit on 28 January 2025. Upon obtaining the record, applicant discovers some errors in the record. The rules of this honorable court and judicial authorities permit a party to apply for the correction of the record of proceedings of a court. That it is in the interest of justice that this honorable court grants the applicant's prayers as sought on the face of this motion. The application is supported by an 18-paragraph affidavit deposed by one Temilade Adekpate, a counsel representing the defendant applicants. Attached thereto are 3 documents marked as Exhibits C1, C2, and C3. The gist of the affidavit in support of the application is that the court should correct its records in the proceedings attached. In defendant applicant's written address in support of the application, applicant's counsel formulated a sole issue for determination. That is, whether considering the special facts and circumstances of this case, the applicant has not made out a convincing case to be entitled to the relief sought in this application. Learned counsel to the applicant submitted that the Honorable Court has the power to correct the record of proceedings in this suit in line with the rules of this Honorable Court, citing Order 26 Rules 9, 10, and 11 of the rules of this court, and also judicial authorities of Audu versus Attorney General of the Federation, reported in 2013, 8th Nigeria Weekly Law Report, Part 1355, page 175, and Daramola versus Attorney General of Ondo, reported in 2000, 7th Nigeria Weekly Law Report, Part 665, page 440 at 462 to 263. Should be 463. That's that in compliance with the stipulated steps to be taken by the party praying for others seeking to correct the records of proceedings, the applicant has filed an affidavit to be served on the court and the respondent, as well as this application, to urge the court to correct its records. Now, this application is not an attempt to urge the court to substitute its record with that of the applicant, but the application is filed in good faith. That to show the good faith, the applicant in the affidavit in support of this application has identified portions of the record which contain the errors complained of with respect to the names of the applicant's counsel who appeared during the trial in this suit at various times, which were misspelled at pages 1, 3, 5, 6, 7, and 10 of the court's record, marked as Exhibit C1. Applicant's counsel also submitted that the statement, quote, when the claimants were in the employment of the defendant, they were issued pay slips from my organization, unquote, attributed to the defendant's sole witness, the W1, on page 8 of Exhibit C1 during cross-examination is inaccurate. To support this, defendant attached Exhibit C2, which is a flash drive containing an audio recording of the court's proceedings of 20th November 2024, recorded by Temilade Adekpate, a counsel in the applicant's law firm, that the relevant segment of the recording as at 1:44 to 1:5:25, that is the time, contains the accurate version of the witness's response. Applicant's counsel urged further that court proceedings are public and not prohibited from being electronically recorded. He referred the court to NAB Limited versus Barry Engineering Nigeria Limited, reported in 1995, 8th Nigerian Weekly Law Report, part 413, page 257. Therefore, the recording was lawfully made. That this application is not an attack on the judge's integrity, but a necessary step to ensure the accuracy of the court records for a fair and effective resolution of the case. The applicant's counsel urged the court to exercise its discretion judicially and judiciously and resolve the sole issue for determination in favor of the defendant applicant. In the claimant's response, in opposition to the defendant applicant's application, one Damilola Badejo, who identified as a litigation clerk in the law firm of counsel to the claimant, deposed to an 8-paragraph counter affidavit with a written address in opposition to the defendant applicant's application. In the claimant's respondent's written address, learned claimant's counsel formulated a sole issue for determination. That is, given the circumstances of this case, whether the defendant's application is not brought in bad faith and thus ought to be refused by the court. In arguing the issue above, learned claimant's respondent's counsel submitted that the defendant applicant's application is brought malified and is an attempt to disrupt the steady proceedings of this suit, that the appellate court had made different pronouncements in plethora of cases on the integrity, genuineness, sanctity, and bindingness of court records of proceedings on the courts and parties. Claimant's counsel submitted further that the defendant applicant's application is unmeritorious, baseless, preemptive, and an attempt to amtreat the court. He therefore urged the court to discountenance the argument of the defendants. Claimant's counsel posited that the defendant applicant cannot force its own private record of proceedings on the court. That it is trite that parties are bound by the court's records. He relied on the case of Impact Solutions Limited versus International Breweries PLC, reported in 2018, 16 Nigeria Weekly Law Reports, part 1645, page 377 at 386, where the Court of Appeal stated thus, quote, the court and parties are bound by the record. An appellate court is not vested with the virus to factor into a record what is not there, nor read out of it what is in it. In other words, it must construe the record in its exact content, devoid of interpolation or subtraction, unquote. He submitted that the record of proceedings recorded by the court is unassailable and parties must be guided by it. Therefore, it is not acceptable for one of the parties to make available its own record for the court to use to correct court's records of proceedings. That this application is injurious to the claimant respondents and must be dismissed by the court. The defendant is trying to doctor the evidence of a witness to suit his case by discrediting the court's record of proceedings. The court has its own recording device and cannot be compelled to rely on the recording made by the defendant, which was done without order of the court. The court can only resort to his own recordings to ascertain the accuracy of the record. That the defendant is not in a position to impose his own record of proceedings on the court, as the record of proceedings is sacrosanct and cannot be added to nor subtracted from by either of the parties or even the judge. He relied on the case of Ugala versus the State of Lagos, reported in 2021, 3 Nigeria Weekly Law Reports, part 1763, page 263 at 271. Learned counsel to the claimant respondent submitted that the so-called Exhibit C2, which the defendant applicant wants the court to rely on, is not the recording of the court, and neither was it made on the order of the court, but rather it is a personal recording by the defendant applicant, which may have been doctored to suit its own purpose. That it is believed that the record of proceedings is genuine, accurate, and a judge is not required to record word for word of what transpires in a proceeding. He relied on the case of Udo versus State, reported in 2006, 15 Nigeria Weekly Law Report, Part 10101, page 179 at 183, where the Supreme Court stated, and I quote, "A judge is not enjoined to record every little detail of what transpires in a proceeding, whether criminal or civil. The important thing is to record all those salient and relevant proceedings that are necessary to lend to a just determination of a case. The crucial requirement is substantial justice in the real sense of it, so much so that no miscarriage of justice is occasioned." And that can be found in page 190, paragraphs D to E. Learned counsel to the claimant respondent, therefore, urge the court to discountenance the applicant's submission and dismiss the application. On receipt of the claimant's counter affidavit and written address in opposition to his application, the defendant applicant deposed to a 15-paragraph further affidavit through Temilade Adekpate of counsel to the defendant applicant with a document attached as Exhibit 4 and a written address on points of law. In his written points of law, learned counsel to the applicant argued that the case of Impact Solutions Limited versus International Breweries PLC, Supra, relied on by the respondent counsel, is inapplicable to this suit and bears no resemblance to the question in issue, which is a rectification of the trial records. The case being on adducing additional evidence at the appellate court that was not recorded at the trial court. This also applies to the case of Ugala versus the State of Lagos, Supra, also relied upon by the respondents. That this case is also inapplicable to this suit as well, because just like the Impact Solution case, it involved counsel trying to rely on a fact not contained in the record of proceedings at the appeal stage without any contention that the said record was incorrect or any attempts to correct them. Unlike this present case, where the applicant is seeking to correct the record at the trial stage. Learned counsel to the applicant reiterated his arguments that a court is empowered to review and correct errors in its records. In the same vein, a party before the court is entitled to apply to the court where errors are spotted on the face of such record following the procedure. That procedurally, in urging the court to correct a record of trial proceedings, the applicant is expected to provide evidence that the record contains error, and the court is determining the applicant's application will then look at the evidence provided by the applicant as against that contained in his record in reaching his decision. He relied on the case of Adeleke versus Asani, reported in 1994, One Nigeria Weekly Law Report, Part 322, page 536, where it was pronounced that, and I quote, "If a party believes that the trial court has not correctly recorded any statement made by a witness, the proper way to challenge the record is for him to produce cogent and positive evidence of what the witness said," unquote. Applicant's counsel submitted that the applicant successfully fulfilled the above condition by annexing Exhibit C2 to the affidavit in support of his motion and commended same to the court. Learned counsel went on to state that it is right that the court is to record salient and relevant proceedings to ensure the just determination of a case. He relied on Soluade, the Commissioner of Police, reported in 2001, 7 Nigeria Weekly Law Reports, part 712, page 432. That in a case where an error in a trial court's proceeding will be fatal to the trial and the court's subsequent decision, the appropriate step is for such proceedings to be corrected to reflect the actual position. He relied on the case of Ibrahim versus States, reported in 2011, 1 Nigeria Weekly Law Report, part 1227, page 1. Learned counsel therefore urged the court to grant this application and dismiss the respondent's counter affidavits. Come to the resolution. Upon careful review and consideration of the facts and circumstances of this instant suit, the processes filed in support and in opposition to the grant of the instant application, the court has decided a sole issue for determination of the application before me. That is to say, whether the justice of this suit requires making the corrections as encapsulated on the face of the motion paper. Paper 1 is for an order of this court correcting the names of the applicant's counsel as contained in pages 1, 3, 5, 6, 7, and 10 of the record of trial proceedings who appeared at various times during the trial in this suit, to wit, Chinasa Onebunam, SAN, Akiola Oyebanjo, Temilade Adekpate, and PB Benoko. Applicant's counsel submitted that this court has the powers to correct the record of proceedings in this suit in line with the rules of this honorable court and judicial authorities, that in compliance with the stipulated steps to be taken by a party praying for others seeking to correct the record of proceedings, the applicant has filed an affidavit to be served on the court and the respondent, as well as this application, to urge the court to correct its records. But the application is filed in good faith. That's to show the good faith, the applicant in the affidavit in support of this application has identified portions of the record which contains the errors complained of with respect to the names of the applicant's counsel who appeared during the trial of this suit at various times, which were misspelled. Generally, the blanket rule on amendments is Order 26 of the National Industrial Court Civil Procedure Rules 2017. In Order 26, Rule 9, 10, and 11, it is provided thus. Rule 9, a judge may at any time amend any defect or error in any proceedings. Rule 10, a judge may at any time correct any grammatical or typographic mistakes in the judge's judgments, rulings, or orders, or any accidental slip or omissions contained therein. Rule 11 says, any of the parties may apply to the court for the correction of any mistakes or errors or any accidental slip or omission in a judgment ruling. In this instant case, it is rules 9, 10, and 11 above that speak to the matter herein in issue. The combined effects of rules 9, 10, and 11 is that a judge may at any time amend any defect or error in any proceedings, correct any grammatical or typographic mistakes in the judge's judgments, ruling, or orders, or any accidental slip or omissions contained therein. And any of the parties may apply to the court for the correction of any mistake or errors or any accidental slip or omission in a judgment, ruling, order, or any process made or issued by the court. In the case of ARCON versus FASA C number 2, report reported in 1987, 3 Nigeria Weekly Law Reports, part 59 at page 4. It was held that the extent of power of court to amend its records, the power of amendment or correction of its records inherent in the jurisdiction of the court is manifestly wide and subject to limitations that it must be exercised when the purposes of justice so require. In the instant case, the court has looked at the records of the counsel's appearance on the days listed by the applicant's counsel, taking the first page dated 13th October 2022 as listed by the applicant's counsel. It is on record that 2 counsel represented the defendant, to wit, Chinasa Onebunam Esquire, together with Akiola Oyebanji Esquire. This is correct, and there is nothing to be corrected here. On page 3 of the document attached by the applicant, dated 7th May 2024, and comparing same with the court record, it is on record that the applicant was represented by Chinasa Onebunam Esquire, together with Yusuf Akiola Oyebanji Esquire, and Cecilia Ben Oko. Same shall be and is hereby corrected to the extent of Yusuf Akiola Oyebanji Esquire and Cecilia Ben Oko now reflects Akiola Oyebanjo Esquire and PB Ben Oko Esquire, respectively. On page 5 of the document attached to the by the applicant, dated 25th June 2024, and comparing same with the court record, it is on record that the applicant was represented by Akinola Oyebanjo Esquire, together with Temi Adekpatse Esquire, and Ben Oko Esquire. Same shall be and is hereby corrected to the extent of Temi Adekpate Esquire and P. Ben Oko now reflects Temi Adekpate Esquire and P. B. Ben Oko Esquire, respectively. On page 6 of the document attached to the applicants, by the applicants dated 2nd July 2024, and comparing same with the court record, it is on record that the applicant was represented by I. Ayobani Esquire, with T. O. Adekpate Esquire, and P. Ben Oko Esquire. Same shall be and is hereby corrected to the extent of T. O. Adekpate Esquire and P. Ben Oko Esquire. Now reflects Temi Adekpate Esquire and P. B. Ben Oko Esquire, respectively. On page 7 of the document attached by the applicants, and comparing same with the court record, it's on record that the applicant was represented by Etigwe Owa, SAN, with Chinasa Onyebulam, SAN, Akindele Oyebanjo Esquire, and Temilade Adekpate Esquire. Same shall be and is hereby corrected to the extent of Chinasa Onyebulam, SAN, Akindele Oyebanje Esquire now reflects Chinasa Onyebulam, SAN, Akiola Oyebanjo Esquire, respectively. On pages 10 of the document attached by the applicants, dated 15th January 2025, and comparing same with the court record, it is on record that the applicant was represented by C. Onebunam SAN with Akiola Oyebanjo and Temilade Adekpate Esquire. Same shall be and is hereby corrected to the extent of C. Unegbulam SAN. Akiola Oyebanjo now reflects Chinas Unegbulam SAN, Akiola Oyebanjo Esquire, respectively. The trial law is that courts of law are bound by their records. They cannot go outside their records, which provide the proceedings before them. See Akinpelu versus Adegbore, reported in 2008, 10 Nigeria Weekly Law Report, Part 1096, page 531, paragraph F. However, when there are typographic errors, there is need for those errors to be corrected. On prayer number 1, which is on record, on the record of names of counsel who appeared at sundry times for the defendant applicants, this court wishes to state that the best person to know the proper and correct spelling of his name is the owner, is the owner of the name or the giver of the name. The names sought to be corrected are not owned by the court, nor given by the court. Hence, since the owner of the names have called the court's attention to the correct proper spellings of their names, the court will so correct its record to align with the proper and correct spellings as represented by counsel to the defendant applicant, and I so hold. I must quickly add that the name of Chinasa Unegbulam SAN was at some previous time recorded as Chinasa Unegbulam Esquire. There is no evidence before me that as of that time, the status of Chinasa Unegbulam SAN had changed to that of a senior advocate. In this vein, all proper recordings bearing this name of Chinasa Unegbulam Esquire remain. On prayer number 2, I would like to point out that when a typographic error issue is raised in the records of the court cannot resort to the records of counsel or parties before it to ascertain accuracy, but its own record. This is so because courts of law are bound by their records, not the records, and they cannot go outside it. See Akinpelu versus Adegbore and others, voted in 2018, LPELR 354, Supreme Court, at page 130. Therefore, the mere fact that a party is allowed the liberty of making an application to court to have its records corrected is not a license to bring in an authorized evidence that was not gotten on the order of the court to substitute the court's records. In this vein, this court cannot but agree with claimant's respondent's counsel that the defendant applicant cannot force his own private records of the proceedings on the court. This is so because it cannot serve the justice of any case for one of the parties to make available its own record for the court to use or adopt as the correct court's records of proceedings. I have gone through the records of the court. I am satisfied that what was given to the counsel as record of proceedings with regards to the testimony of DW1 on the answers he gave during the cross-examination are correct and align with the court's records. In this vein, there is nothing to correct and nothing to add, nothing to alter, and I so hold. Consequently, prayer number 2 on the motion paper is bound to fail because it is not only injurious to the claimant respondents, the court, and justice of this case, but a ploy to add to the court's records what is not there ab initio. In view of the foregoings, whereas applicant's prayer 1 succeeds, applicant's prayer 2 fails, and same is hereby struck out. And that is the ruling. The court makes no orders to costs. And ruling is entered accordingly. Yes.
My Lord,
Very well.
this is counsel to the defendant. I got the ruling while doing my duty now, so I could not join the meeting early enough, my lord.
Oh, I can't hear you clearly. Please, can you repeat what you've just said?
Yes, my lord. This is Temilade Adepati.
Okay. I didn't record you.
Yes, my lord. I'm just saying that I got the link to the ruling while the ruling was being announced, so I couldn't join early enough. I wanted to announce my appearance.
Very well. Is your name, please, and please spell it for me.
Very well.
Temilade.
Temilade Adepati.
Temilade.
M-I.
Yes.
L-A.
Yes.
D-E. Temilade.
Yes.
Then Adepati. A-D-E.
Yes.
P-A-T-E.
Okay.
Yes, my lord, for the defendant.
Okay. Yes. For the defendants.
Yes, my lord. My lord, I'm most grateful.
Very well.
We are most grateful, my lord.
Very well. Thank you. Okay. So, when are we coming back? My registrar. I hope you know the next step we are going to take. Miss Adekpat. Yes, do you know the next step we are taking?
I believe that should be for adoption, my lord.
Yes, it's going to be for adoption. So we are going to adjourn for adoption. Yes. Do you have a diary here?
October 30th.
How about October the 30th? 30 October.
It's convenient, my lord.
Okay. Is it convenient for everybody?
My lord, please, just a moment. I'm trying to check my diary, my lord.
Okay.
Oh, October 30th is not convenient, my lord.
I see.
Oh.
How about 28th and 29th of the same month of October?
28th is not convenient.
Okay. 29th?
29th is...
29th is convenient.
29th is not so convenient. I think I'll go with 30th, my lord. I think I'll go with 30th. Yes, my lord.
Okay. 30th is okay, my lord. 30th is okay.
All right. For the adoption of the final written addresses of both learned counsel to the parties. Very well. Yes. Okay. Jair. So we have another ruling. Please call up the ruling.
Case number NICM/LA/96/2022 between Mr. Jaye Olafatungache and Staco Insurance PLC.
May my lord be pleased.
Yes.
Frank Eke for the claimant applicant.
Very well.
I'm grateful, my lord.
Yes.
May I please the court?
Yes.
A.O. Shomoye. Shomoye is spelled S-O MOYE for the defendant.
Okay.
Respondent.
May the court be pleased.
Yes.
CP Chidi. My humble appearance is for the party that is party sought to be joined, my lord.
Okay. Very well. So this is the ruling of the court. The claimant filed a complaint before this court against the defendant dated the 19th day of March 2019, praying for the following reliefs. A, the total sum of 4,453,297 naira 98 kobo, being the outstanding salaries due to the claimant, as made up as follows. One, salary for the month of October 2019, 745,888 naira 98 kobo. Salary for the month of November 2019, 749,871 naira 68 kobo. 3, salary for the month of December 2019, 606,034 naira 33 kobo. 4, salary for the month of January 2020, 750,834 naira 33 kobo. 5, salary for the month of February 2020, 750,834 naira 33 kobo. Salary for the month of March 2020, 750,834 naira 33 kobo. 7, the sum of 99,000 naira only, being the excess amount deducted from his salary. B, terminal benefits in the sum of 33,200,000 naira. C, interest in the sum of 4,453,297 naira 98 kobo, and the sum of 33,200,000 naira only, at the rate of 21% per annum from the 31st day of March 2020 till date of payment is finally made. D, the sum of 1 million naira as general damages. And E, the sum of 1 million naira to the claimant being the cost of this action. Filed alongside the complaint is a statement of facts and other accompanying processes. The defendant, in response, filed a memorandum of appearance, statement of defense, and other processes. The claimant, on the 28th day of February 2025, filed a motion on notice praying the court for the following reliefs. 1, an order joining Mr. Bayo for Korede as the second defendant in this suit. 2, an order granting leave to the claimant applicant to amend his complaint and the statement of facts herein, marked as Exhibit A and B, in terms of the underlying words in the proposed amended complaint and amended statement of facts attached to the affidavit in support, and filing a fresh claimant's witness's deposition on oath and other processes, and also reflecting the name Mr. Bayo Fakorede as the second defendant in this suit. And 3, for such further or other orders as this honorable court may deem fit to make in the circumstances. Accompanying this motion on notice is a 12-paragraph affidavit deposed by one Jayeola Fatungase, the claimant in this suit. Also filed is a written address wherein claimant's counsel raised A, whether this honorable court ought to grant the application to join the proposed second defendant in this instance suit. B, whether this honorable court ought to grant the application of the claimant applicant to amend his processes accordingly. On issue number 1, claimant's counsel, citing Order 13, Rule 4 of the National Industrial Court Civil Procedure Rules 2017, and the case of Diko Yusuf versus Obasanjo, reported in 2004, 7 MJSC 1 at page 52, paragraphs D to I, submitted that claimants may, at his option, join all persons who are severally or jointly and severally liable to him on any relief alleged to exist as parties to the same action. He argued that the joinder of the second defendant as a party to this suit will ensure that justice is done because he is a necessary party and is also jointly and severally liable to the claimant applicant. He stated that aside from the fact that the proposed second defendant is the alter ego of the first defendant, it was he, as the managing director of the first defendant, who originated and instigated the non-payment of the claimant's salary out of preconceived malice and his attitude towards the claimant and other employees of the defendant. Counsel equally submitted that it will be fair and in tandem with the spirit and letters of Section 36, Sub 1 of the Constitution, as amended, for the court to join the proposed second defendant as a party to this instance suit and allow the claimant applicant leave to amend his processes to reflect same as the non-joinder of the said parties will amount to a breach of the right of fair hearing of the claimant applicant. Counsel urged the court to so hold. On issue number 2, counsel submitted that by Order 26, Rule 1, Sub 1, 2, and 3 of the National Industrial Court Rules of the court, a party may amend its pleadings and originating processes at any time on such terms as to cause or otherwise as the court or judge may think just, and all necessary amendments shall be made to determine the real questions or issues in controversy raised or arising from the proceedings. He also submitted that the defendant will not be prejudiced in any way if the application is granted. He urged the court to grant the application as filed. The defendant respondents on the 4th of March 2025 filed in response a 23-paragraph counter affidavit deposed by one Shola Bamishe, the human resources personnel in the office of the defendant's respondent. Also filed is a written address wherein counsel for the respondent raised the sole point, thus, whether this honorable court ought to refuse the claimant's applicant's application in its entirety. On this sole issue, counsel, citing the cases of Green versus Green, reported in 1987, Kosa versus Kita, reported in 1992, OK Contract Point Limited versus Progress Bank PLC, reported in 1995, and also in all these cases, the citations are very well supplied. And also Order 13, Rule 4 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 submitted that the rules of the court do not override the settled principles of law, which state that only parties necessary for the court to effectively determine a matter should be joined in a suit before the court. He also submitted that the defendant respondent can defend itself and is indeed the only party that has an employment contract with the claimant applicant. Counsel on this urged the court to so hold. Counsel, in response to the applicant's argument concerning the amendment, submitted that the amendment sought will overreach the defendant's respondents as it seeks to change the character or nature of the facts and facts in issue on which claimant's assertion is predicated. He relied on the case of Anthony Ehidimhem versus Amadou Musa and another, reported in 2004 Supreme Court, Part 3, page 166. He stated that the court, we have no difficulty agreeing that all the paragraphs of the statement of facts, except paragraph 31, are sought to be changed and amended. He posited that the matter, though slated for commencement of trial, has been stalled again by the claimant applicant, and therefore the court should have no hesitation in refusing the prayer sought. Counsel urged the court to refuse to exercise its discretion and consequently strike out the claimant's applicant's application in its entirety with substantial cost. The proposed defendants on the 7th day of March 2025 filed a 12-paragraph counter affidavit in response to the applicant's motion on notice. Accompanying his counter affidavit is a written address, and counsel on his behalf raised a sole issue. That is to say, whether this honorable court ought to join the proposed second respondent, who is not a necessary party to this suit. On the said sole issue, counsel submitted that the proposed second respondent does not meet the criteria for being classified as a necessary party, as this suit can be factually determined without the proposed joinder of the second respondent, who at the time the applicant filed this motion was retired from the first defendant. He argued that the first defendant is a going concern and can sue and be sued as a proper party in this instance. He cited the cases of Esowe and Oriel Plastic Limited, reported in 2022, 17 Nigeria Weekly Law Report, Part 795, page 155 at 181, paragraph G to H. And also GTB Noble, reported in 2019, 14 Nigeria Weekly Law Report, Part 1693, page 389 at 412, paragraph C to E. Counsel submitted that the authorities cited in support of the applicant's contentions are in contradistinction to his application, as the proposed second respondent is not a necessary party to this suit because he has retired from the first respondent and thus cannot be held liable for conduct or acts done for the first respondent. Counsel urged the court to dismiss the applicant's application with substantial costs. The applicant, in response to the respondent's counter affidavit, filed on the 12th day of March 2025, an 11-paragraph further and better affidavit. And accompanying the affidavit is a reply on points of law. And counsel on behalf of the applicant raised a sole issue. That is, whether this honorable court ought to refuse the claimant applicant's application in its entirety. It is a counsel for the applicant's submission that the respondent's argument that the proposed second defendant ought to be joined as a necessary party is misconceived. Counsel argued that parties are an integral part of any proceedings. He stated that it is not unreasonable to hold the view that no parties, no action in court. Council further submitted that failing to join the interested party as a co-defendant who is alleged to be the author, originator, and instigator of the stoppage of the claimant's salaries would defeat the cause of justice. He argued that the claimant's application to join the party is therefore competent and should be granted. He urged the court to so hold. The applicant, in response to the proposed second respondent's counter affidavit filed on the 18th day of March, 2025, a 9-paragraph further and better affidavit. Accompanying the document is a reply on point of law, and counsel on behalf of the applicant raised the sole issue. That is, whether this honorable court ought to join the proposed second respondent who is not a necessary party to this suit. On the preliminary, counsel submitted that the counter affidavit filed by the proposed second defendant as the deponent, as well as the written address, is incompetent and ought to be struck out because the deponent is not a respondent and he is yet to be joined as a party. And only parties on an action are entitled to respond to applications in court, and that he failed to comply with Order 17 Rule 10 of the National Industrial Court of Nigeria Rules 2017, which requires a respondent served with a motion on notice who intends to oppose the application to file his counter affidavit and written address within 7 days of the service of such application. Based on this ground, counsel urged the court to discountenance the counter affidavit. On the issue raised, counsel submitted that the proposed second respondent argued that he retired from his position as acting managing director of the first respondent, is no longer involved or responsible for the affairs of the first respondent, having unilaterally taken decisions without consultation to stop the salaries of the claimant's applicants. He submitted that, I will repeat the last sentence. On the issue raised, counsel submitted that the proposed second respondent argued that he retired from his position as acting managing director of the first respondent and is no longer involved or responsible for the affairs of the first respondent, having unilaterally taken decision without consultation to stop the salaries of the claimant applicants. He submitted that the proposed second defendant sought to be joined as he is personally responsible for his action and may be held liable in his personal capacity. Counsel urged the court to discountenance all the submissions and arguments of the deponent who is yet to be joined as a party, and consequently grant all the prayers of the applicant with a consequential order that the second respondent enter his defense. Okay. After a careful consideration of the complaints and the accompanying processes filed in this suit by the claimant, as well as the motion on notice filed by the applicant, the counter affidavit of respondent, and the written submissions by both counsel in respect of the motion on notice and the reply address of the applicant's counsel, it is my respectful view that the issue appropriate for the court's determination is whether or not this court can grant this application. It is the applicant's deposition via this affidavit in support of his application that one Bayo Fakorede, who is alleged to be an erstwhile managing director of the respondent at the material time of applicant's employment, ought to be joined as a necessary party to this suit. For ease of reference, I reproduce the pertinent deposition thoughts. 8. D. that it is expedient for the proposed second defendant, being the alter ego of the first defendant, to be joined in this instance suit upon revelation of evidence that the gravamen of this case arose out of the actions of the second defendant. That that is paragraph E, says that the malicious acts of the second defendant as instigator and originator of the facts in this suit led to the stoppage of my salaries from July 2019 until I was frustrated to unfortunately resign my appointment with the first defendant. Paragraph F says that the proposed second defendant exhibited transferred malice against me due to my refusal to indict one Mr. Sakiru Oyefeso, the former managing director of the first defendant, in a case of financial misconduct the first defendant leveled against him in court. Paragraph G says that the proposed second defendant was actively the mastermind, instigator, and originator of the query or memo that led to the non-payment of my salaries. Paragraph H, in light of the revelation in paragraphs D, E, F, and G above, it is expedient to join Mr. Bayo Fakorede as the second defendant in this suit. Paragraph I says that Mr. Bayo Fakorede is jointly and severally liable to the claimant applicant with the first defendant. And paragraph K says the joinder of Mr. Bayo Fakorede as the second defendant, respectively, as a necessary party will ensure a just and final determination of this matter, unquote. The respondent, in response, argued that it is the only party capable of being sued, as the party ought to be joined as he never acted in his personal capacity concerning the employment contracts that existed between it and the applicant. The respondent continued that the party sought to be joined is not a necessary party, nor would it be bound by the outcome of this suit. Generally, the joinder of any person to proceedings before a court is governed by the rules of court in which the action is commenced. It is a discretionary power vested in the court, which may be exercised suo motu or upon application by any of the parties to ensure the just, effective, and complete determination of the issues in controversy. The primary rationale for joinder is to avoid multiplicity of suits, prevent unnecessary delays, and promote judicial economy. The guiding principle for determining whether a person should be joined to a suit is whether that person has an interest in the subject matter and whether failure to join them would prejudice their rights or inhibit the court's ability to effectively and completely adjudicate the matter. The courts have consistently held that the real test is whether the party sought to be joined is a necessary party. That is a person whose presence is essential for the effectual and complete resolution of the dispute before the court. See the cases of Magaji and another versus Ojuenku reported in 2019, Akinyede versus Akinyede reported in 2017, Green and Green reported in 1987. All other 13 citations are all supplied. Then other 13 rules 1 and 7 of the extant rules of this court provides that, and I quote, all persons may be joined in one action as claimants in whom any right of relief is alleged to exist, whether jointly or severally, and judgments may be given for such claimants as may be found to be entitled to relief, and for such relief as the claimant may be entitled to without any amendments. Then section 7 says, a claimant may, at the claimant's option, join as parties to the same action, all or any of the persons severally or jointly and severally liable on any reliefs in the matter. It is well established that the grant or refusal of an application for joinder lies within the discretionary powers of the court to be exercised judicially and judiciously based on the facts and justice of each case. The court's discretion in this regard is not arbitrary, but guided by the interests of justice and in the need to avoid multiplicity of suits. It is also right that all persons who may be affected in one way or the other by an order of the court in any matter before it ought, as far as practicable, to be made parties to the suit. Whether such persons are proper, desirable, or necessary parties, the legal implication is the same. They should be joined in order to bind them by the eventual outcome of the proceedings. The primary consideration in joinder applications is to ensure that any person who has a legal interest in the subject matter or whose rights or obligations may be affected by the outcome is allowed to be heard and bound by the results. The court must avoid making orders that affect the interests of persons who are not before it. Whether a party shows sufficient legal interest in the subject matter and demonstrates that he or she intends to be bound or will be prejudiced by the outcome of the case, failure to join such a party creates a procedural lacuna which the court ought not to overlook. This position finds support in the decision of Supreme Court in Green and Green, Supra, where the court held, and I quote, the guiding principle in determining whether a person is a necessary party is whether he is a person who ought to have been joined as a party and whose presence before the court is necessary to enable the court to effectually and completely to adjudicate upon and settle all the questions involved in the cause or matter. Similarly, in the case of Pinnock Investment Limited versus Hotel Presidential Limited, reported in 1982, 12 Supreme Court 1, page 1, the court held, and I quote, the test is whether the party whose joinder is sought has an interest in the subject matter of the suit, of the dispute, and whether the order sought in the proceedings will directly affect him. Also, in Ijebu-Ode local government versus Adedeji Balogun and Co., reported in 1991, 1 Nigeria Weekly Law, page 166. Part 166, page 136. The court emphasized that, I quote, a person who is likely to be affected by a decision of the court must be made a party so that he may be bound by the decision. See also the cases of Easy Street Limited versus MV Cosmos and another, reported in 2019, LPELR 48161, Court of Appeal. And also the case of First Bank of Nigeria versus Ozokwere, reported in 2013, citation supplied. A pertinent question to be answered is whether the party sought to be joined is a necessary party. Or better put, will the party be bound by the outcome of the suit? To effectively answer this question, a cursory examination will be made of the applicant's complaint dated 19th day of March, 2019 before this court. And for ease of reference, I reproduce the same. The claimant's claims are for a total sum of 4,453,297 naira 98 kobo, being the outstanding salaries due to the claimant as made up of one. I've already said that in this ruling, made up of salary for the month of October 2019, November 2019, December 2019, January 2020, February 2020, March 2020, in various sums, and also the sum of 99,000 naira, which amounts to the excess amounts deducted from his salary. And also terminal benefits, and also interest in the terminal benefit in the sum of 33,200,000 naira. The third one is interest on the sum of 4,453,297 naira 98 kobo, and the sum of 33,200,000 naira. And then the sum of 1 million naira general damages.
Sorry,
Yes. And lastly, the sum of 1 million naira to the claimant, being the cost of this action. From a careful examination of the above claims, it is clear that the applicant's claims are for salaries, terminal benefits, interest on monies claimed, general damages, and costs. I cannot find anywhere where the claimants specifically for the alleged personal acts of the proposed respondents, or where the proposed respondents will be personally bound by the outcome of this suit. It is trite that a managing director of a company may be joined in a suit under specific circumstances. These are if allegations of personal misconduct, fraud, or unlawful termination are made directly against the managing director in their capacity. Secondly, if their actions, decisions, or omissions are central to the fact in dispute. And thirdly, where personal reliefs are sought against them. However, if the claim relates strictly to the company's corporate acts, the managing director is generally not a necessary party, as a company is a legal person capable of being sued. See the cases of Lakomi versus Adin, reported in 2003, 10 Nigeria Weekly Law Report, part 828, page 353. The case of Trenco Limited versus African Real Estate Limited, reported in 1978 to Supreme Court, page 43. And then the case of Aquilo versus FBN PLC, reported in 2003, 3 Nigeria Weekly Law Reports, part 806, page 443. As stated supra, it is the applicant's grievance that the malicious acts of the proposed second defendant led to the stoppage of his salaries from July 2019 until he was forced to resign his appointment with the first defendant. I have perused the document before this court, and I cannot find where the applicant has proven his deposition in this regard. It is trite that he who assesses must prove the existence of his assertion. See the case of Senator Smart Adeyemi versus All People's Congress and others, reported in 2023, Legalpedia 17112, Supreme Court. It is evident that the claims of the applicant, as articulated in the complaints, disclose no cause of action against the proposed party sought to be joined in a personal capacity. Accordingly, the only proper and necessary party to be sued and to defend this suit in its entirety is the defendant. This reasoning is premised on the settled principle that a company, being a corporate legal entity with a distinct personality, can sue and be sued in his name. The actions of his officers or managers are, in law, deemed to be the actions of the company itself, acting through its disclosed agents. The company does not possess independent consciousness or volition. Its officials merely execute corporate functions. Accordingly, when corporate acts are in issue, the company itself, rather than its officers in their capacities, is the sole proper party to be sued. See the case of New Treasure Suit Nigeria Limited versus Mr. Ikechukwu Maduka, reported in 2022, JELR 109331, Court of Appeal. From the foregoing, I find that the applicant's application for joinder fails, having held that the proposed defendant sought to be joined is not a necessary part. I so hold. The applicant also prayed to this court to amend his complaint and the statement of facts herein marked as exhibits A and B in terms of the underlined word in the proposed amendment and amended statement of facts attached to the affidavit. In support, I'm filing a fresh claimant's witnesses, deposition on oath, and other processes, and also reflecting the name Mr. Bayo Fakorede as the second defendant in this suit. By Order 26(1) of the rules of this court, 2017, it provides that 1, an amendment may be allowed where its purpose is to determine the real question or issue before the parties and would A, secure substantial justice, or B, settle the controversy between the parties and related issues. 2, an amendment may be refused where it would A, present a completely different case or cause injustice to the other party, or where the application for amendment is brought malified. B, where it necessitated the hearing of further evidence, especially on appeal. C, not cure the defect of the procedure sought to be cured, or where it is inconsistent and useless. And D, where it amounts to overreaching the other party or an abuse of court process. Flowing from the findings earlier made, it is evident that granting the proposed amendment would overreach the party sought to be joined and thereby occasion manifest injustice. In the circumstances, I find no merit in the applicant's prayer. Accordingly, the application is hereby refused and dismissed in its entirety. I so hold. Yes, and there is no award as to costs.
As the court pleases, we thank the court for the well-considered ruling.
Thank you. Thank you.
We equally thank your lordship for the well-researched ruling. We're grateful.
Yes, thank you very much. So, when are we coming back?
We'll be taking a trial date because it's already ripe for trial.
Yes, we are taking a date for that.
November 12th.
What do you say to the second day of November?
12th.
12th. The 12th day of November, please.
It's convenient, my lord.
It's not convenient, my lord. It's not convenient for me.
11. 13.
11th of November.
Yes.
Yes, 11th
It's
is convenient.
11th is convenient.
So 11 for everybody.
Yes, my lord.
Okay. Okay. That will be for hearing, for trial.
As the court pleases.
As the court pleases.
Yes. So that's what it is. The matter is adjourned to 11th day of November 2025 for trial.
As the court pleases.
Okay. 14, 25.
The application was dismissed.
Okay. So, please call the next case.
Case number NIC/LA/86/2024 between Mr. Four, Inspector Kayode Gabriel. 5, the Registrar Koram Court 1, Magistrate Court of Lagos State, Ebusemeta Magisterial District. My lord, parties are absent.
Okay. Appearances, please. Appearance.
May you please this honorable court?
Okay. Appearances.
I am Angela Jesu.
Angela.
May you please this honorable court? I am Angela Jesu Daniels.
Please.
My appearance.
Obvious reasons, yes.
ANJOLAJESU, Angela Jesu. Then Daniels.
Okay. This Jesu is in capital letter J. Is it one word?
No, it's together. It's one name.
Okay.
Yes, my lord.
Okay. Angela Jesu. Who?
Daniels, my lord.
Okay. That's clear. Yes. You're appearing for
the claimant, my lord.
Okay. Yes. It's on the other side.
With respect to this honorable court, BT,
Yes.
Adebomi,
ET.
for the first defendant.
Please spell your
BT.
name. Yes.
Adebomi is ADE.
Yes.
BOMI.
Okay. That's clear. Yes. You are for the defendants. Well,
Defendant.
you are for Adegbomi Esquire. Whom are you representing? Counsel. E.T. Adebomi Esquire. E.T. Counsel. 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 All these other ones are muted. Except me. So this one.
I think this is the counsel. This is
Angela.
Daniels.
Yes.
Yes, my lord.
You are appearing for
The claimant, my lord, Angela Jesu Daniels.
the claimant. Okay. How about E.T.? E.T. Adebomi, Esquire. Hey.
I think she's the first defendant, my lord.
That's what I want to know. Who amongst the defendants? Okay, for the defendants. You should let me know who exactly she's defending, because there are many defendants.
First defendant.
I guess I can go ahead and read out the ruling.
Western Associates Limited, my lord.
Who? Okay, wait, that's the first defendant.
Yes, my lord.
Okay. So how about the second, third, fourth, and fifth defendants? Okay, they are not represented. Second, third, fourth, and fifth defendants not represented by council. It is read all of them. Eh? Really? Okay. So this is the ruling in this case. This is the ruling of the court on an application filed on the 20th day of May 2024 by the first defendant applicants, brought pursuant to relevant rules of court and under the inherent justice of this court, seeking the following. A, an order of this honorable court vacating the interim order of this honorable court made on the 23rd day of April 2024, ex debito justaciae. B, an order of this honorable court dismissing this suit for lack of jurisdiction to entertain the same. The last prayer is the only first prayer. The grounds for the application are: one, that the respondent's claim before the court by nature is that of an enforcement of a purported breach of fundamental rights. B, that the first respondent suppressed material facts from the court in order to secure an interim order of this court to suspend the criminal proceedings of the Magistrate Court number 1, Ebute Metta, Lagos State, in charge number BG/A07/2024. The IGP versus McAnthony Nwankwo. But the third one is by virtue of section 6 sub 5K of the Constitution of the Federal Republic of Nigeria 1999 as amended, the Magistrate Court number 1, Ebute Metta, Lagos, is a competent court cloaked with requisite jurisdiction to entertain charge number BG A07/2024. That is Inspector General of Police versus McAnthony Nwankwo, which borders on obtaining by false pretense and the offense of stealing the first applicant's money in the sum of 100 million naira. The fourth ground is that the provision of section 29 of the Magistrate Courts Law of Lagos State gives the Magistrate Court of Lagos State requisite jurisdiction to preside over criminal matters, including but not limited to charge number BG/A07/2024, Inspector General of Police versus McAnthony Nwankwo, brought pursuant to section 411, 315, and 287 of the criminal laws of Lagos State. 5, that this suit, as constituted, is premature and unmaintainable against the first applicant. 4, moreover, the mandatory provisions of Section 195 and Section 211, sub A, B, C, 2, 3 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, clearly states that the Honorable Attorney General of Lagos State is the chief law officer, cloaked with inherent powers to institute, suspend, take over, and or withdraw a criminal charge against an accused person charged before a court of law. 7, that by the combined effect of statutory provisions of Section 69 and Section 70 of the Administration of Criminal Justice, in brackets, repeal and re-engagement law of Lagos State 2015, the second respondent is subject to the supervisory direction of the Attorney General of Lagos State in the prosecution of a criminal charge. 8, furthermore, that the suit as instituted by the first respondent is an abysmal abuse of judicial process and a clear violation of the settled statutory and judicial principles of law. Then 9, on the judicial authority of Nnanna versus Nwanebe, reported in 1991, 2 Nigeria Weekly Law Report, Part 172, page 181. This Honorable Court is without power to interfere with the pending proceedings of magistrate courts or any court of competent jurisdiction whatsoever until the final determination of the matter. That it is a settled principle of law that the institution of Nigeria Police cannot be stopped from performing its constitutional and statutory duties of investigation, invitation, arrest, and prosecution of a suspect. Council respectfully refer to the decisions of Universal Investment and Development and others versus Itoru and others, reported in 2021, LPELR 53414, Court of Appeal. And that authorities are in harmony to the effect that a court of law shall not fall victim of being speculative or be seen to act on speculations as clearly displayed by the first respondent in this application. We respectfully commend the courts to these decisions. They refer to these decisions, that is Oguonzi versus State, reported in 1998, 5 Nigeria Weekly Law Report, Part 551, page 521 at 555. Edakpu and Emine versus the State, 1992. Bafa versus Odili, 2001. Citations fully supplied. The court of law are not allowed to be moved by sentiments. Referring to the case of Esowe versus Ohaniere, the Supreme Court reported in 1978. Then the case of Umeji versus Attorney General of Imo State, reported in 1995, 4 Nigeria Weekly Law Reports, Part 391, page 552. And that no recognizable right of action ought legitimately to inure on the first respondent against the first applicant before this court, and that this honorable court lacks jurisdiction and ought not to assume jurisdiction in this matter. This application is supported by a 23-paragraph affidavit deposed by one Glory Esowe, a legal practitioner in the law firm of the applicant's counsel, Attached thereto is a document, which is a copy of the enrolled order of court dated 23rd April 2024, marked as Exhibit WA1. In compliance with the rules of this court, applicant also filed a written address. In the applicant's written address, learned counsel on behalf of the applicant formulated a sole issue for determination, and that is to say, whether the applicant is entitled to the relief sought, having regard to the facts as contained in the applicant's affidavit and the settled principles of law. Learned counsel to the first defendant applicant submitted that the issue of jurisdiction is sacrosanct to every legal action, in the absence of which such action will amount to nullity. He relied on the case of Akere and others versus the governor of Oyo State and others, reported in 2012, LPELR 7806, Supreme Court. That it strikes that the jurisdiction of any court to adjudicate in any case or matter is conferred by the Constitution and or statute which creates it. He relied on the case of Tunsa versus Federal Republic of Nigeria, reported in 2018, 17 Nigeria Weekly Law Report, part 1648, page 238. He submitted that the Magistrate Court 1 Ebutemeta has jurisdiction to hear criminal cases pursuant to section 61 and 5K of the 1999 Constitution as amended, which vests judicial powers in courts established by law and allows states' houses of assembly to create courts with original or appellate jurisdiction over matters they can litigate on. That the above constitutional provisions empowered the Lagos State House of Assembly to create a law establishing the Magistrate Courts of Lagos State, empowered with criminal jurisdiction, resulting in the provisions on section 29, sub 1, 2, and sub 7 of the Lagos State Magistrate Courts Law, 2009, which grants magistrates the power to summarily try and determine criminal cases, subject to constitutional or legal restrictions. Learned counsel also submitted that the first respondent abused the judicial process by withholding material facts and misleading the court into granting an interim order suspending criminal proceedings at the magistrate court. That the suit and relief sought by the first respondent were filed with the intent to improperly quash lawful proceedings, thereby constituting an abuse of court process. That this court lacks jurisdiction to issue the interim order. No, it lacked the jurisdiction to issue the interim order it did on the 23rd April 2024, as it did not act within its appellate review or transfer powers. He relied on the case of Nnama versus Nwanebe, Supra, where the Court of Appeal held that a court's inherent jurisdiction cannot be used to override the statutory limits, and that the High Court acted unlawfully by interfering with the magistrate court's proper exercise of its criminal jurisdiction. That furthermore, the conduct of the first respondent seeks to evade justice. However, the court has a duty to uphold justice of every case. Therefore, the appropriate court to adjudicate on criminal charge number BG/A07/2024, Inspector General of Police versus Mark Anthony Nwankwo, is the Magistrate Court, Ebutemeta, Lagos State, where the charge is pending and first in time. Excuse me. Learned counsel to the applicant argued that the constitutional and statutory powers of the Attorney General of the state to control criminal prosecutions as provided in Section 211 of the 1999 Constitution and Section 70 of the Administration of Criminal Justice Laws of Lagos State 2015 allows persons like the second respondent to prosecute criminal cases on behalf of the state, but only under the specific direction of the Attorney General. That the Attorney General or his delegate has the full authority to conduct a criminal prosecution from start to finish, and that this prosecutorial power cannot be challenged or suspended by any court. He referred the court to the case of Akilu versus Fawehimi, reported in 1989, 3 Nigeria Weekly Law Report, Part 112, page 685, where the Court of Appeal held that the Attorney General's discretion in prosecution is not subject to judicial control, provided it is exercised in good faith and in the public interest. That in view of the foregoing, the second and third applicants have the exclusive powers to prosecute the first respondents, being officers of law under the supervision of the Attorney General of Lagos for public interest and in the interest of justice. And that the court frowns upon people approaching it with a view to seeking a restraining order to prevent lawful prosecution. He relied on the case of Universal Investments and Development and another versus Itoro and another, Supra. Learned counsel to the first defendant therefore urged the court to discharge the interim order and dismiss the fundamental rights action. In opposition to the first defendant applicant's application, the claimant deposed a 4-paragraph affidavit through the claimant himself, attaching thereto a document which is a copy of charge number FHC/L/1776/2024, IGP versus McAntony Nwankwo, marked as exhibits MA1. The claimant also filed a written address in compliance with the rules of this court. In the claimant respondent's written address, the Learned Counsel formulated 3 issues for determination, and these are: 1, whether the first defendant's notice of preliminary objection is competent, same being supported by an invalid affidavit. Secondly, whether the claimant, it needs charging. Okay. Secondly, whether the claimant validly commenced this suit by a mode recognized by law or by due process of the law. And thirdly, whether this honorable court is invested with jurisdiction over this suit, including power to have granted its
I don't know the person showing us his sitting room during the court proceeding, lying down on his couch while the court proceeding is going on, showing us his beautiful face. It's a very strange thing, huh? Somebody lying down on his couch, showing us his face, his sitting room. I'm feeling very comfortable doing that while the court proceeding is going on. I am you.
Please, what's going on is like his lordship has gone off. Please, can the court officials let us know what's going on?
Please, we can't hear anything from this side, please. Please, can we get the audio? We can't get anything.
I can't get anything from here. Are we still on?
Is anybody seeing me? Are you seeing me?
Yes, my lord.
Yes. Yes, my lord. We can see you now.
Okay, okay. So we shall continue. So, let me add it. So the learner counsel to the first defendant respondent therefore urged the court to discharge the interim order and dismiss the fundamental rights action. In opposition to the first defendant applicant's application, the claimant deposed to a 4-paragraph affidavit, we've done this before, through the claimant himself, attaching thereto a document which is a copy of the charge, IGP versus Mark Anthony Wankwo, marked as Exhibit MA1. The claimant also filed a written address in compliance with the rules of this honorable court. In the respondent's written address, learned counsel to the claimant respondent formulated 3 issues for determination. And these are whether the first defendant's notice of preliminary objection is competent, same being supported by an invalid affidavit. 2, whether the claimant validly on the 23rd day of April 2024. On issue 1, learned counsel to the claimant respondent challenged the propriety of the affidavit filed by Glory Ehinzwenlen, a legal practitioner from Andel Solicitors, who also acts as counsel for the first defendant, arguing that Glory deposed a 23-paragraph affidavit in support of the first defendant's notice of preliminary objection, while also appearing as counsel in the same suit. That this dual role violates paragraph 20 sub 1 of the 2023 Rules of Professional Conduct, which prohibits a lawyer from acting as a counsel in a case where they or their firm may be called as a witness. That none of the exceptions in paragraph 20 sub 2 of the Rules of Professional Conduct, such as testifying on formality, unrelated matters, or legal fees, apply in this situation. Thus, the applicant's affidavit in support of the notice of preliminary objection is procedurally improper because it was sworn to by a counsel actively representing a party in the same case in controversial rule. He relied on the cases of UCHIV versus Sabo, reported in 2016, 16 Nigeria Weekly Law Report, part 1538, page 267 at pages 306 to 307, paragraphs H to A. Furthermore, counsel urged the court to wholly discountenance and strike out the first defendant's notice of preliminary objection and affidavits, same being incompetent in law. On issue number 2, learned counsel to the claimant respondent submitted that the applicant argued that the claimant's suit was incompetent because it was initiated by complaint that is akin to writ of summons instead of by originating summons or application as already required, as allegedly required under the Fundamental Rights Enforcement Procedure Rules, 2009. In response, the claimant argued that the defendant's reply by counter affidavit and written address was also improper, as a proper response to a complaint is statement of defense, not affidavit, thereby raising two issues of whether the claimant's suit was commenced by due process of law and whether the first defendant counter affidavits and written address were appropriate response. Then the council submitted that fundamental rights actions are sui generis, governed strictly by the FREP rules, which under Order 2, Rule 2, permits commencement by an originating process accepted by the courts, not only by an application. He posited that Ara versus Ugu, the case of Ara versus Ugu, reported in 2016, and Skybank versus Njoko, also reported in 2016, affirmed that the FREP rules prevail and must be given a clear literal interpretation. The Claimants Council argued that since the claimant's suit is for interpretation and application or enforcement of its fundamental rights under Chapter 4 of the Constitution, the use of a complaint to commence the action is valid under the FREP rules as provided under Order 3, Rule 22 of the Extant Rules of this Court, 2017. Therefore, the first defendant's objections are unfounded. On issue number 3, that is, whether this Honorable Court is invested with the jurisdiction over this suit, including power to have granted this ex parte order of 23rd April 2024, Council submitted that the first defendants misconceived in their submissions on this head, that by section 6 sub 3 and sub 5 of the Constitution, there are only 10 superior courts of record in Nigeria, and the magistrate court is certainly an inferior court of record, being not listed in section 6 sub 5 CC of the Constitution as a superior court. That the law has always been that every superior court of record has supervisory jurisdiction over proceedings of inferior courts to ensure that inferior courts do not act outside their jurisdiction. Thus, a superior court has always had the inherent powers to order the removal of proceedings of an inferior court into the superior court for the purpose of quashing them. He relied on the cases of Attorney General of the Federation versus Aguna, voted in 1995. Then Miscellaneous Offenses Tribunal versus Okorafor, voted in 2020, reported in 2001. Citations fully supplied. That it is clear from the pleadings of the claimants that the claims of the claimant and the relief sought by the claimant in this suit are directly connected or incidental to the claimant's employment with the first defendant. So this suit falls within the exclusive jurisdiction of the National Industrial Court by virtue of section 254C of the Constitution. Council further argued that the Magistrate Court of Lagos State lacked jurisdiction to try criminal charges arising from employer-employee relationships, such jurisdiction is specifically conferred on the National Industrial Court of Nigeria by section 254C, sub 5 of the Constitution. That being an inferior court, the magistrate court can only exercise jurisdiction explicitly granted by law. Any jurisdiction not expressly stated is excluded. He relied on the case of African Newspapers of Nigeria Limited versus others, and others versus the Federal Republic of Nigeria, reported in 1985, 2 Nigeria Weekly Law Report, Part 6, page 137 at 159 to 160. That's section 254C5 of the Constitution vests the National Industrial Court with criminal jurisdiction over matters connected to employment relationship. There is no law granting such powers to magistrate courts. Therefore, the claimant's arraignment before the magistrate court by the defendant is unconstitutional and invalid. Additionally, the claimant invokes section 351C of the Constitution, arguing that his right to personal liberty was violated, as it can only be curtailed on the basis of a reasonable suspicion of committing a crime, not mere suspicion. He relied on the case of DSSS, Kano, and another versus Nadi, reported in 2020, LPELR 52031, Court of Appeal. Thus, the magistrate court acted without jurisdiction, and the claimant's constitutional right to liberty was unjustifiably infringed. That in the present case, the magistrate's arrest, detention, and arraignment for theft and obtaining money by false pretenses initiated by his employer, the first defendant, were unjustified, since the alleged payments were approved by the first defendant's managing director and chief executive officer. The submission of the learned counsel to the claimant responded that the arrest, detention, and arraignment of the claimant was unconstitutionally and infringed on the claimant's right to personal liberty. Against this backdrop, counsel urged the court to dismiss the first defendant's preliminary objection and proceed to hear the substantive suit. On receipt of the claimant respondent's process in opposition to his application, the first defendant applicant filed a reply on points of law, dated the 3rd February 2025, on whether the applicant's notice of preliminary objection is incompetent solely on the ground that it was supported by an affidavit deposed to by a legal practitioner. Counsel submitted that they are not oblivious of the provisions of the rules of professional conduct cited by the respondent's counsel, but that the said rule is subject to certain exceptions. That the deponent, Glory Esquire, Ehizuen Esquire, has never appeared before this court in this matter. Thus, she was competent to depose to the affidavit. Furthermore, the content of the affidavit in support of the notice of preliminary objection was not contentious. The deponent merely reiterated facts that were already before the court. In addition, the law is right that a notice of preliminary objection need not be supported by an affidavit if the ground for the objection are based on law, or if the facts the applicant wishes to rely on are already placed before the court by the respective parties. He relied on the case of Nkanola versus Government of Osun State and another, reported in 2020. LPELR 50412, Court of Appeal. Thus, the applicant's notice of preliminary objection is competent. On whether the documents accompanying the claimant's substantive actions are competent, counsel submitted that the essence of the preamble to the FREP rules is that human rights suits shall be given priority in deserving cases where there is any question as to the liberty of the applicant or any person. The case shall be treated as an emergency. Counsel further argued that a full trial is unnecessary in a fundamental right case, as it would defeat the overriding objective of the FREP rules, which is to ensure speedy and simplified enforcement. Therefore, the respondent's processes filed by the complaints are incompetent and should be disregarded. That the respondent should be directed to file a statement, affidavit, and written address as required by the FREP rules. That the respondents claim that the applicant's counter affidavit and written address are incompetent is misguided, as Order 2, Rule 6 of the FREP rules permits a respondent to file a written address and optionally a counter affidavit. In summary, the applicant maintained that the FREP rules, not regular court rules, govern the procedure, governs the procedure, and that both the respondent's processes and objections are procedurally defective, and so should be discountenanced, and the respondent should be ordered to comply with the FREP rules. Resolution. Upon careful review and consideration of the facts and circumstances of the instant suit, the pleadings, the process filed in support and in opposition to the grant of the instant application, this court has distilled the sole issue below for determination, and that is to say, whether there is merit in this notice of preliminary objection hearing brought by the first defendant applicant. Before addressing the issue distilled above, I would like to address the objection raised by the claimant respondent to the affidavit of the applicant deposed by a legal practitioner, which, according to the claimant, a legal practitioner signing an affidavit is contrary to the Legal Practitioners Act. He had urged the court to declare the notice of preliminary objection as incompetent, meaning that the affidavit is defective for being signed by a legal practitioner in violation of the Legal Practitioners Act. First of all, there is exception to the provision of the Legal Practitioners Act on legal practitioners representing a party and signing affidavits. A non-contentious affidavit like the one deposed by the legal practitioner is one of such exceptions. There is nothing in an affidavit in support of a notice of preliminary objection that is contentious, nor is there anything that will warrant the legal practitioner to be called to the witness box to give evidence in support of an affidavit of such nature. In this view, the claimant only stretching the provisions of the Legal Practitioners Act beyond its scope. Secondly, by the very nature of a notice of preliminary objection, the applicant is not under any legal compulsion to depose an affidavit in support of his notice of preliminary objection. The notice alone with a written address suffices. Therefore, the arguments and objections of the claimant respondent on this head go to no issue, and I so hold. Yes, that said, I will proceed to addressing the sole issue distilled by the court. That is, whether there is merit in this notice of preliminary objection brought by the first defendant applicant. On prayer 1, which is for an order of this honorable court vacating the interim order made on the 23rd day of April 2024, ex debito justiciae. Learned counsel to the applicant submitted that jurisdiction is sacrosanct to every legal action, and that magistrate court has jurisdiction to hear criminal cases pursuant to section 6(1) and 5K of the 1999 Constitution, that it is the duty of the court to discourage abuse of judicial process. Also, that the executive power of the Attorney General of a state or police officers to prosecute criminal offenses is meant to be carried out without judicial interference, and that second and third defendants have the exclusive power to prosecute the claimant respondents. Hence, an order of this Honorable Court vacating the interim order of this court made on the 23rd day of April 2024, it's the Bito Justitiae. Because the first respondent suppressed material facts from the court in order to secure the interim order of this Honorable Court to suspend the criminal proceedings of the Magistrate Court number 1, Ebutemeta, Lagos State, in charge number BG/A07/2024, Inspector General of Police versus Macantoni Nwankwo. That by virtue of section 6, subsection 5K of the Constitution of the Federal Republic of Nigeria, the Magistrate Court number 1, Ebutemeta, Lagos State, is a competent court cloaked with the requisite jurisdiction to entertain the charge mentioned above, which borders on obtaining by false pretense and the offense of stealing the applicant's money in the sum of 100 million naira. The claimant respondent, on the other hand, argued that the Magistrate Court is not a superior court of record and so does not have the jurisdiction to try criminal cases as the present case. Hence, the opposition to keep the matter before the court. By virtue of Order 47, Rule 16 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, it is provided that, quote, a party to a matter may apply to the court to vacate its order of injunction within 14 days of the date the order was made, unquote. Furthermore, Order 47, Rule 22, Sub 1 of the NICN Rules 2017 reads, and I quote, the court may so motu or on application of any party affected, correct, rescind, or vary its orders or rulings, A, erroneously sought or erroneously granted in the absence of any party affected by it, B, in which there is an ambiguity or patent error or omission, but only to the extent of such ambiguity, error, or omission, and C, granted as a result of a mistake common to the parties. From the above provisions, an application of this matter to the court to vacate, vary, or correct its decision in rulings or / judgments is not out of place. In this vein, and as rightly argued by the applicant, this court has the unfettered power to vary, set aside, or discharge the interim order made or granted on the 23rd April 2024, if the facts and circumstances so warrant. Also, being that the ruling hearing sought to be vacated was made by way of ex parte, it is appropriate to reproduce Order 47, Rule 26.1 of the NICN Civil Procedure Rules 2017, which specifically takes care of matters ruled on by way of motion ex parte. The said rule provides that, and I quote, in any matter in which by an interim order of court is restraining any of the parties from doing or compelling the doing of any particular thing within or before a stated time or period, any of the parties in the matter may, by an application and or motion on notice, ask the court to either vacate, alter, or amend the said interim order, unquote. The interim orders made or granted by this court on 23rd April 2024 read 1. An order of this Honorable Court staying all further proceedings in charge number BG/A07/2024 IGP versus McAntony Nwankwo, pending at the Magistrate Court of Lagos State, Ebutemeta Magisterial District, Quorum Court 1, pending the hearing and determination of the applicant's motion on notice dated 22nd April 2024. 2. An order of interim injunction restraining the second to the fourth defendants from taking any further steps in respect of charge number BG-A07/2024 IGP versus McAntony Nwankwo, pending at the Magistrate Court of Lagos, Ebutemeta Magisterial District, Quorum Court 1, including but not limited to withdrawing, discontinuing, proceeding with prosecution, amending, or however dealing with charge number BG-A07/2024 IGP versus McAntony Nwankwo, pending at or before the Magistrate Courts of Lagos State, Ebutemeta Magisterial District, Quorum Court 1, or any other court, pending the hearing and determination of the applicant's motion on notice dated 22nd April 2024. 3. An order of interim injunction restraining the second to fourth defendants from further arresting, detaining, or howsoever harassing or intimidating the applicant, whether in furtherance of or pursuit to charge number BG-A07/2024 IGP versus McAntony Nwankwo, pending before the Magistrate Court of Lagos State, Ebutemeta District, Quorum Court 1, or any other proceedings whatsoever on issues arising from, under, or in respect of the employer-employee relationship between the first defendant and the applicant, pending the hearing and determination of the applicant's motion on notice dated the 22nd day of April 2024. Now, the orders above were made since April 2024 on the last span of interim order, Order 15, Rule 14, 9, and 10 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 provides that, I quote, an order of injunction made upon an application ex parte shall abate at the end of 7 days upon hearing and determination of the motion on notice, or as the court may otherwise direct during its ruling. And Rule 10 says, the court may, in the interest of justice and upon an application, extend the effective period of an interim order of injunction made ex parte, either to be extended from time to time or to last until the hearing and determination of the motion on notice for interlocutory injunction, provided that the application for extension is made not more than 7 days before the expiration of the order for interim injunction. From the above provision, an order of interim injunction is not an order that lives nearly forever, like Methuselah, but limited to a lifespan of 7 days. What this means is that after 7 days, an interim order expires by a fluxion of time. On the other hand, the lifespan of an interim order can be elongated, just as the lifespan of Hezekiah was elongated by 15 years in the book of 2 Kings 20, verse 6. However, just like Hezekiah, the elongation of the lifespan of an interim order is not automatic, but by request or application. As it stands, There has been no application for the elongation of the lifespan of the interim order made since April 2025. To this end, the order has since expired, and I so hold. In this vein, prayer one of the applicants succeeds to the extent that whatever orders made by the court with regards to the interim injunction sought and granted the claimant expired since 7 days after the orders were made. As such, orders are hereby officially vacated. Prayer number 2 touches on the heart of the substantive suit of the claimant, as the prayer sought is to dismiss this suit for lack of jurisdiction. Now, the claimant's respondent's matter before the court is that of an enforcement of purported breach of fundamental rights. In the case of SCC Nigeria Limited and another versus Joseph and another, reported in 2020, LPELR 49764, Court of Appeal. The Court of Appeal had this to say, and I quote, "The disputes concerning application of Chapter 4 of the 1999 Constitution, over which the National Industrial Court has exclusive jurisdiction, is limited to those connected with a matter which the court has jurisdiction to hear and determine by virtue of Section 254C, sub 1 to D of the 1999 Constitution, which provides that notwithstanding the provisions of sections 251, 257, 272, and anything contained in this Constitution, and in addition to such other jurisdictions as may be conferred upon it by an act of the National Assembly, the National Industrial Court shall have and exercise jurisdiction to the exclusion of any other court in civil cases and matters." Sub D says, relating to or connected with any dispute over the interpretation and application of the application of the provisions of Chapter 4 of this Constitution, as it relates to any employment, labor, industrial relation, trade unionism, employers association, or any other matter which the court has jurisdiction to hear and determine. The NIC has no jurisdiction to try allegations of commissions of crime. That is why allegations that an employee has stolen his employer's property are tried by courts with the jurisdiction to try criminal offenses, such as magistrate courts and high courts. Such criminal cases are not tried by the National Industrial Court. Even where the thefts occurred at the workplace and during the employment, since it has no jurisdiction to try allegations of crime, it has no jurisdiction to entertain a civil cause related to or connected with a dispute as to the application of Chapter 4 of the 1999 Constitution, arising from the appellant's suspicion or allegation that an employee attempted to steal or actually stole properties belonging to the employer. In all fairness to the claimant, this case, the powers of the National Industrial Court as encapsulated in the 1999 Constitution are enormous, but they have not powers that any the courts with jurisdiction to hear criminal matters that are between state and the accused, nor can it sit on appeal of such criminal matters or exercise supervisory jurisdiction over magistrate courts or criminal matters. For all intents and purposes, criminal matters are not matters between an employee and his employer, as envisaged by Section 254C of the 1999 Constitution. Rather, They are between the accused and the state. This court lacks the jurisdiction in criminal matters of the state versus the accused. In this vein, being that the fulcrum of the substantive suit of the claimant is to cloak the court with borrowed robes that do not belong to it, this court must, as a matter of law, justice, and equity, decline jurisdiction in this suit. And so I hold. Yes, in this vein, prayer 2 of the applicant's notice of preliminary objection succeeds. I would like to reiterate that this court, as a court of law, justice, and equity, cannot and will not interfere with the criminal proceedings pending at the magistrate court or court of competent jurisdiction. The law is also well settled that the institution of the Nigeria police cannot be stopped from performing its constitutional and statutory duties of investigation, invitation, arrest, and prosecution of a suspect. From all that has been said above, the court finds merit in the notice of preliminary objection by the first defendant applicant. Same succeeds and same is hereby granted. Consequently, the order of interim injunction made on the 23rd of April 2025 is hereby vacated, and this suit is hereby dismissed for the court lacks jurisdiction, requisite jurisdiction to entertain it. I make no orders as to cost, and parties shall bear their respective costs, and that is the ruling of the court.
As the court pleases, we are most grateful.
Okay. Thank you.
As God pleases. My Lord, I want to ask when we'll be able to get the CTC of this ruling.
Actually, I think it depends on you this time. You do the needful, you make the, you apply, yes, you bring the application. And this is a good time to get it quickly because even though the staff of the court are still working on the so many cases that we have, I'm sure they will bring it out for you. It will be signed today.
Okay, my Lord. Thank you, my Lord.
Yes. So just make the appropriate application and you will get it.
Thank you, my Lord.
Eh? Okay. This one is, no, this one. The court last jurisdiction, yes. So which one is a Fidelity Bank?
Yes, my Lord.
Okay. Please call the next case.
Case number LICM/LA/383/2021 between Fidelity Bank PLC and Chukwuji.
Appearances, please. Appearances, please.
May it please the court.
Yes.
Chinedu Nneke. Respectfully, Nneke is spelled N-N-E-K-E, N as in Nigeria.
Yes.
With me is Udenna Chukwulobe. Chukwulobe is spelled respectfully C-H-U-K-W-U-L-O-B-E. But we
Please
appear
come
for
again.
the claimant.
Please start again. Chukwu, I've gotten that one.
Udenna Chukwulobe.
Okay. Udenna Chukwu.
Yes.
Chukwulobe, is it one word?
Chukwulobe, one word. Yes, my lord.
Okay. Chukwu
Lobe, L-O-B-E.
Okay.
Yes. We are for the claimant.
Okay. Yes. Who is on the other side? Who is on the other side?
The defendant is in court. I can see him. I think he's still.
He should unmute. He should unmute. Maybe he's not aware that he's muted.
Okay, he should unmute himself. I cannot do it here.
Let me send a message to him.
Please. He has gone to say he wants to tell the other person to unmute himself. Yes. Mr. Nneke.
I have sent a message to the defendant's counsel.
Okay.
But I'm sure you can.
Okay. Well, this is going to be an adoption, and he should come first, usually.
Yes, my lord.
Yes, my lord. Yes. So I wonder what do we take yours when he comes? He will. Or do we deem it to have been adopted since we can't stay here forever?
Maybe we should deem it as adopted. If it comes, he can do a reply.
Cancel. Without. It's therefore deemed adopted. Okay. So it comes to the claimant's counsel. Yes, I guess you can.
We find the final written address dated 20th March 2024.
Yes.
Which I adopt respectfully as the argument final address in this matter. Malo, the course of the matter, I will be very brief.
Yes.
The defendant periodically at different times invaded the claimant's headquarters and other banking premises.
Yes.
At different locations in Nigeria. And disrupted the claimant's business activities. And they vowed to continue until the claimant is intimidated to succumb to their demands. It took the intervention of the Honorable Court for this to stop. After we have told the defendants. In fact, it was admitted.
Okay.
This means that trespass and nuisance has been established. Because facts admitted other proof.
Okay.
Because
Mr.
the court will render judgment on
Off
that
record,
particular
counsel.
claim.
Counsel,
Yes, my
off
lord.
record, what is the situation now? Do they still do that?
They are not doing that because of the order of court.
Okay.
Asking them to stay away. Pending the termination of this matter.
Okay. Very well. I wanted to know. Okay.
Then the only issue that is dispute is whether the defendants were employees of the claimant or not.
Okay.
But we exhibited letters of employees of the defendants and the acceptance of the employment. We showed that they were employees of FSL Management Services Limited, seconded to the claimant. And upon completion of the task, for which they were deployed to the claimant, they were returned to the employer. They were not sacked. The exhibit D1 to 59 set out the contract of employment of the defendants, which the defendants accepted. So we respectfully invite the honorable respect to the intention of the parties as expressed in all the documents before the court. Particularly exhibit D1 to 59 and exhibit C1. And enter judgment in favor of the claimant according to the claims set out in the complaint and the statement of facts.
Okay.
We are grateful, my lord.
Yes. Okay. He's still not back. This man is muted now. He's still not back. So we take it.
No, there's no.
If I'm permitted, I can call it. Maybe he's having challenges.
Would communicate it to them.
Yes, Mr. Chinedu.
As adopted.
Yes. He's muted. Mr. Chinedu.
Yes, Your Lordship.
Okay. You have adopted. So,
Yes, my lord.
I'm saying that the date for the judgment shall be communicated to both of you, for both counsel.
As the court pleases.
Yes. So date.
We are very grateful, my lord.
Very well. They're very, very, very plenty. That's why I was asking off record. What did he say?
No, it's not the one that I called. It's the Chinedu's car. He said it's Chinedu's
Okay.
colleague.
Okay. There's Amos Tokwe Ogundijo. Is that?
The council's name is Holiday George.
Who?
Holiday George.
Okay.
Oh, the Holiday George.
Holiday George, yes. George Holiday.
When he calls me, tell him now.
Please, if and when you see him, you tell him, please, we are going to communicate the date to them, to you, to both parties.
Yeah, I will send a message to him right now.
Thank you very much. Okay. So that is the case for today.
As the court please.
As the court please. Court.
Chineke me. 177 others.
The same holiday that wrote that the adoption is taken.
Chinedu. Mr. Holiday. Mr. Holiday George is online. I wonder why he didn't join. I've just been looking at the proceedings. I hope he's aware.